Hello everyone and welcome to Inside Rosenberg and Estis. My name is Alex Estis. I'm a member of the firm's litigation department and I'm pleased to welcome you inside Rosenberg and Estis in our studio located inside Rosenberg and Estis. This is our second podcast in this studio and we hope you stick around to see many more that we'll do here. Today we're going to talk about probably one of the most important topics that we can talk about if you are a landlord or a property owner in New York City. And that is how to manage your property. And to manage your property, I brought two fine property managers with us today. Here we have Joel Davis and Ernest Rrika, who are the founders of Peninsula Property Management, one of the fastest growing boutique property management firms in New York City. They've been operating for about a year now, and they are expanding at an incredible rate. Joel and Ernest, welcome to Inside Rosenberg and Estis.
Thank you.
Thanks for having us, Alex.
No problem. It's a pleasure to have two fine property managers as yourselves. So, Joel, I've had the pleasure of knowing you for close to 10 years. Ernest, I've now known you for about 6 months, but it's felt like close to 10 years at this point. But I want you guys to tell us a little bit about what is Peninsula Property Management, or PPM, how did it come about, and what is it that you guys look to offer that might be different than other property management companies?
Sure. Why don't you go and introduce yourself first?
So Ernest and I oversee the operations and construction for Peninsula and all the day-to-day activities, including best practices and workflows.
I'm Joel Davis. I'm the president of Peninsula Property Management. By way of background, I graduated George Washington University, majored in hospitality. I ran the W Hotel for some time in Union Square, and then I fell into real estate and never looked back. I would say most recently I was at a very large firm, and I decided to roll off and open my own shop. We're a very hospitality-forward firm. We really think that it's really important for the actual experience in the buildings, for whether it's on the Upper West, Upper East, white glove service, or the different downtown vibe. We really want to make it hospitable for all those that live in the building. We really go great lengths to do so. So we offer trainings to all the staff to understand the building, understand the clientele in the building, and we want to make it the best possible place to live. Aside from that, I think what we do differently is we're very tech forward, in the sense that we have workflows and streamlines to keep everybody in the community, especially the board, apprised of all information. And I think that is super important, being transparent on everything that's going on in the building, and it really has been working.
Yeah. It's also, I would say, from day one, the operations and the streamlining, the workflows, having the chance to do it from the beginning and scratch as you're onboarding buildings has actually been one of our strengths, because transitioning between systems or onboarding new things is time consuming, a lot of training. So we were lucky enough to have built up the right infrastructure from day one to support our clients and buildings.
So, Ernest, Joel, you mentioned before offering a hospitality-based approach to property management. I know, Joel, you had a lot of experience in hospitality, and Ernest, you've stayed in hotels and experienced hospitality. What would you say that is like? How would you describe the hospitality approach and how that differentiates you, and what is the potential benefit to a landlord or property owner of a hospitality-based approach?
Sure. I think the hospitality approach makes it more of a community, and it makes it a greater place to walk into, be greeted. As I said, there's different sects in the realm there. Some are white gloves, some are more, of a different feel. Some people want to be called their first name. Some people want to be called, Mr. Estis. So it's really getting a feel for the community at large and getting a feel for what everybody wants. We teach our staff to, check in with every tenant, ask them in advance when they move in, what do you want to be called, things like that. But it's also just in general being hospitable to everybody who walks in. So guests, even the people delivering groceries, and dog walkers. We want to make sure it's a nice place to walk into, because if you're a guest and see that everybody's being greeted kindly, it really does make it a warmer place.
How do you approach that from an operational standpoint, Ernest, in terms of making sure that's effectuated, and how will owners actually see that from the actual management, whether it's an owner operating a rental building or a condominium board?
So I think one of the ways it goes down to communication, and when there's hospitality approach or care, and it carries over to everything we do. So we really try and plan ahead, put ourselves in the residents' shoes, especially when we're planning long-term capital projects, thinking of who does it affect, how long, it was the best way to plan everything, and how to communicate it and make sure that everybody is understanding and you're attending to all their needs and just doing everything on a hospitality basis.
So now that you guys are growing and moving along, I wanted to ask you both, and here's one of the big things I wanted to talk about today. What are the issues you're seeing with property managers in terms of how they operate and they're affecting owners? Because as you both know, I'm a litigator, and people only call me when something goes wrong and they're unhappy. No one's really that happy to ever call me because they have a big problem going on in their life. So what are the issues that you're seeing that are mismanaged in properties, and what are you doing to try to avoid those issues, and what should people be cognizant of?
I think honestly, it's funny you bring it up with your profession. I think the biggest fear in property managers is discussing things with the attorneys for the boards or the buildings at large. And I think that the attorney is there to really assist. Property managers are usually set to interpret bylaws or proprietary leases on their own and tend to not ask questions and believe wholeheartedly that they understand them, when in fact sometimes they do have questions. So we empower our managers at least to not only reach out to attorneys, but reach out to oversights like myself and Ernest, who've been doing this a long time. We help them understand what the bylaws are. It shouldn't be scary to ask for help with something that really obviously matters a lot, because they have to understand what's going on in the building.
And also just education for putting board members as well as our staff for best practices and new things that are coming up. Everything from as small as an alteration agreement and the documents we put forth to any compliance items that are coming up and how to comply within time before anything else. When you don't do it the right way or when you do it in time, it snowballs and creates a larger effect. So really getting ahead of it and being proactive and communicating what ramifications are and how to really put a strategy to compliance or documents or anything we do with a strategy approach.
It's interesting you guys say that, and I couldn't agree with you more, because from a legal standpoint, the buildings in which I've had the biggest problems with any tenants or landlord-tenant issue are the ones where the property manager came to us months later after they tried to handle it to themselves. Now, that's not a knock at property managers. There's some great ones that really know what they're doing, but every property manager should consult with their legal attorney to make sure they're handling it the right way. Because a lot of property owners work very hard to acquire the property, to buy that asset, and they want to make sure it's managed well. The most successful assets, to me, are the ones that are managed in synergy with good property management and legal advice. And this way, if you get your legal team involved sooner, you may not need them later on. That's how I always look at it. I agree with that. I've handled a bunch of litigations recently where the property manager tried to resolve the issue themselves, not knowing the law, and actually, funny enough, tried to use AI and ChatGPT to do deferral agreements with tenants and certain agreements with tenants. And then 6 months go by and the contract's bad, and the tenant then got more rights than they were supposed to, and the landlord then had a huge mess. So it's funny. I really like seeing AI incorporated in a lot of places in society right now. Having people use it for the law and not using it in conjunction with their attorneys is not a good thing. So I wanted to ask, because it's a very popular topic nowadays, have you guys used AI in your business at all? Have you integrated into property management in any way at all?
Yes, of course. So with our workflows, Monday.com has an AI platform that helps streamline and create the workflows. Obviously, we're doing the updating on them, but it helps populate the right workflow for each building, which has been super helpful. We're also working with an AI team that specializes in property management, so that we're going to set up, a text or email. We see some people don't like to call in, don't like to email in, so there'll be a texting service where it asks questions, and you say my toilet's leaking, you text with it, it asks a few questions, you send a few pictures, it generates the work order to the super through the property management system. The super comes, takes care of it, and you can close it out, all without actually calling or emailing.
You can do this through text messages?
Correct.
Through SMS or iMessage?
That's correct.
Well, that's great, because most people end up having to go online and do a portal, and I hear all these horror stories about how tenants are complaining and they need repairs made to the landlord, and the landlord just misses them. Do you find it's a more direct approach, and that it's a better streamlined communication for you?
Very direct approach. It's been great. And honestly, for the condo co-op boards, we populate, bylaws and alteration agreements, certificate of insurance, all of those needs into it. we used to do that. I mean, we still do it in Building Link as well, but we do it through this AI system. So the most popular time to request one of those documents is Saturday at 8 in the morning, when obviously we don't generally have, unless there's an emergency, generally have somebody answering emails for things like that. So they can get it instantly through the text, email, any way they want it. It comes directly to them because it's populated.
And then I think one of the main things for AI too is it's not there to replace professionals or professional opinions. Half the time, those answers are way off because of the information it doesn't have. I think AI is great for workflows or taking a certain step and helping enhance communication between team members and updating everyone and just having a workflow in place for when each step. So when this is done, notify this person, and everybody is in sync. But it's not there to give you legal advice or make legal contracts. Or it might help you make a memo, but definitely not legal.
Yeah, I think it's very good for memos and things like that for the junior property managers. Talking about leaks and things like that, you can generate it into ChatGPT. Does this make sense? Did I leave anything out that would be more transparent to the community? And it'll point out, you should say the hours, or the date, obvious, but the date range for like a larger project, things like that. So it really has helped streamline memos, but doesn't replace obviously people, or it's good for grammar.
It's very good for grammar, I'll tell you that. But you mentioned that you deal with this Saturday mornings at 8 a.m. How often are you guys working Saturday mornings at 8 a.m.?
Every week.
Every week?
Always on my emails. Check in at least every hour.
That's a good property manager right there. That's lawyer hours right there.
Exactly.
So it seems you get a lot of communications over weekends. Is that right?
Yes. Yeah.
And how often would you say you guys respond to either a tenant inquiry, or if it's a condo building or co-op building, a board inquiry?
On the weekends?
On the weekends, or just in general?
So in general, we have a policy with all of our employees. If an email comes in before 3 p.m., they get a response same day. If an email comes in after 3 p.m., everybody gets a response before 10 a.m. the following day. On the weekends, I generally don't expect all of the managers to reply. So, if I'm copied on the email, I'll respond saying, if it's important, obviously I will respond with the answer. Otherwise, I'll say you'll get a response on Monday, just so that they know that we've seen it. And it's something that needs to be looked into. Obviously, we don't have it at our fingertips, on the weekends.
I have to say, I'm very privileged that I get to work with a lot of great property managers in New York City for our clients, but it's very hard to come by property managers that are responsive in the way you just described. Why is it that you guys have a policy that way to interact? What is your belief around it, and why do you think it benefits your clients?
Personally, I think communication is key in property management. I think it's the biggest hurdle this industry faces, and I think communication goes a long way. You have an upset person writing to you about obviously something going on in their unit, which they own. It is their prized possession. It might be something that they've overextended themselves, whatever it may be. It is something that really matters to them, and being heard really matters to them. So obviously responding quickly, even if the response is, I need a day or two to get back to you, I wholeheartedly believe that de-escalates the situation.
It's interesting you say that, because I actually believe the three of us are in the same industry. It's not just that we're in real estate, or I'm in law, you're in property management. We are in the service industry.
Correct.
We are here to service our clients, and anyone that has ever dealt with anyone in the service industry hates bad service, meaning that they can't get a hold of whoever they're looking for. You go to a restaurant, you can't get a hold of your waitress, you don't like that. You can't get a hold of the waiter, it's a problem, everyone's upset. You can't get customer service on the phone to talk about what you ordered on whatever website you ordered. That's an issue. Everybody wants to hear from who they are paying to hear from in a timely and prompt fashion. And that is imperative in real estate in New York, because we deal with a lot of emergencies and issues that come up, such as floods or any other tenant problems, and you have to be on 24/7, no difference in the law as well.
Couldn't agree more. We have a policy for the executives at our team here. Everybody gives out their cell phone number. It's in my email signature. People can get me anytime, day or night.
And it's also, even when we're seeing or talking to potential clients, the number one thing that we have always seen or issue is always communication. Sometimes it's not even the fact that they have an issue, but it's the fact that they cannot communicate the issue. So we are trying to stop the revolving door of communication issues as well. So that's why it's such a strict standard, because once you let that standard slip, it goes worse and worse.
I couldn't agree with you more. And I don't think there are too many property managers, probably also not too many lawyers that take that level of service to answer calls 24/7 or get up in the middle of dinner to take a work call, which I do all too often, and my wife is very appreciative when I do that. She's always a fan when that happens. Thankful that I don't get in trouble for that too often, but no, but it's really an important thing, and I'm glad to see that you guys are doing that. So it seems that you're growing quite rapidly. How many buildings would you say you guys operate right now?
Currently have 29 under operation with another 4 contracts signed.
How long have you been in operation?
A year.
A year?
Yeah.
Busy year.
It's been a very busy year.
29 with another 4 signed. And what do you attribute to that pace of growth?
I think it's really a lot of word of mouth. We've gotten a lot of business through word of mouth. We've met a lot of people. We've connected a lot of people. And, you know, once people are happy with us, they tell others, they tell other board members, they tell other owners, and it's been great for us. So we've met so many people in the last year. I can't even tell you a number.
Also, even the we talked about earlier, all of the tools and things that we've built for scalability as we've taken on new buildings, having all the right infrastructure to support everything from all built from compliance to leasing to management to administrative items. Having all of that built out lets us operate and bring on new buildings without affecting the service that we're bringing to new buildings. So a lot of the systems that we've built to are attributed to the growth as well.
No, it's really impressive that the scale at which you guys are expanding your practice. How much collaboration would you say in your operational standpoint do you involve legal attorneys into your day-to-day, whether it's a tenant issue or just acquiring new buildings or any sort of operational standpoint?
I would say we speak to attorneys, I don't even want to say on a daily basis. I'd probably say on an hourly basis. You know, it's important to keep them apprised of what's going on in the buildings. I wouldn't say we do it, you know, out of necessity or anything, but it's just very important. You know, there's legal matters going on in the buildings, and the attorneys need to be the first to know about it.
And also, even just for our practice and then bringing that practice on to the buildings, learning what the best practices are from council and seeing what the regulatory updates are, if any, and, you know, making sure that we're making any updates along the way so we don't open any liability.
I think there's a common misconception that, you know, property managers really only deal with project managers, architects, and engineers, but the attorneys are underrated. We speak to attorneys every hour.
So since you speak to your attorney on an hourly basis, what does a successful attorney-property manager relationship look like to you guys?
Yeah, in my mind, I don't know if we speak to them on an hourly basis, but we're in contact with them on an hourly basis. You know, emails come in, they need to be privy to things. You know, they have court dates coming up. You know, you don't want them to miss anything. So, you know, a forwarded email. What time are you free to talk? Here's the issue below. Things like that. You know, we find time, whether it's just through email, because sometimes it's imperative that they know something. They're already on their way to court, whatever it is. It's great to be very proactive with the attorney so that they're apprised of everything.
And sometimes even just seeing them on the matter, just so they're aware if you're unsure, it's better that they know and can address it and see it rather than, you know, not forwarding it over, not having them privy to the matter.
You know, I'm really glad you guys say that because I couldn't agree more. Because as I was saying this earlier in the podcast, but the more often you get your attorney involved and the more you communicate, the less likely there is to be an issue. Sometimes it's unavoidable and you could be consulting with your attorney from minute one and things happen and no one can stop that. But the better kept in the loop the attorney is, the better advice that could be given and the better coordination and tandem that could be created, I think really benefits property owners, landlords, and developers all over the city. And I also think it provides a better experience for the tenant because sometimes certain property managers may be misinformed, they don't know what the law is, and they tell the tenant the wrong information, and it could sour the relationship between the tenant and the landlord, even though the landlord doesn't know what's going on, but they rely on you to do so. So how important do you think it is to maintain that relationship with the tenant for any rental buildings that you manage?
I think it's imperative. I mean, you hit it right on the nose, but I mean, 100%.
Even when I'll go actually back to one thing. You said having a good relationship with an attorney or an attorney that you can rely on. It's also you build a good workflow with them. So even what we were saying earlier, where it's not being charged when, you just seeing on it. So they know when to step in and correct you when needed. And it's good to have a good working relationship and know each other communication style.
So really it's just a people business, isn't it, when you think about it?
It's crazy.
It's hard to find good representation that has the right interpersonal skills, right? At the end of the day, really, I've always looked at it that you can have 10 people, 10 attorneys, 10 property managers that they're all qualified, they have the same years of experience. How do you pick between each one? You end up picking the one that you like the most, the one that seems most personable, the one that you want to do business with, and the one that you think is going to be able to advocate and achieve your result the best. Because I think people don't want to deal with individuals that they're just going to be off-putting and be rude to them. There is that human layer there of personal relationships and ability to speak to one another. And I think in your field, in addition to law, but in your field, I think that's everything, because tenants are coming home, they were working their 9-to-5 jobs, and they get home and then they see something going wrong in their apartment. They don't want someone that's not going to respond to them or just going to be off-putting to them. They want someone that's I think what you just described, Ernest, and what you just described, Joel. Someone who's going to be able to listen to them and talk to them and give them that real human interaction.
And also, when you said for interpersonal or just the relationship you have, also sticking to what you promised to them and keeping it on a timely basis to, when to fulfill what you're saying, it does help build a lot of the relationship even with the tenant, even if they know it will take X amount of days to fix it, as long as, it's being said and the promises are being kept. That does also help mitigate any potential friction between the tenant and the landlord and manager.
How do you handle, though, when you make a promise and something comes up and then the tenant creates an issue? Because I think that's a problem that a lot of property managers see. They think they could fix something, or they just overpromise more than they should. So how do you manage expectations with the tenant? Or if something arises where you didn't keep it, how do you address it on a human level with that tenant?
I think you need to be 100% transparent with them. Let them know what came up. Let them know what's going on. Let them know, not that you're in over your head, but that you bit off more than you could chew. Is the saying, but I think it really starts from not overpromising. I think you deliver more than you promise. I think that's the right way about it, because you see it a lot in the industry when people overpromise. There's a lot of frustration. There's a lot of friction. So as long as you communicate, I think you give the picture and then you overdeliver.
And also just setting the expectations. You have to understand a lot of times, even, for example, board members deal with, they are not professional real estate day-to-day operators. So taking the time and explaining, what the proper steps are, which each steps entail, so they at least understand if there's any issues that arise during such step, why, and, it's not just a frustration buildup, but they know this caused this, and, the next step after this one will be a little bit delayed.
So speaking of frustration, what would you say is the most frustrating thing you see in the property management field that you would like to change, or that you may do better already?
It's a good question. I think there's so many things that could get frustrating in the industry.
You can say as many as you want. You don't have to label it to one.
I think some of the biggest frustrations in community and in the life in the buildings is some people may arch on how often they email and things like that. So we really streamline that. When we do a project, we phase out all the emails so that people are in the know of what's going on. Because I've seen it in previous companies and roles and things like that. If you keep communicating, people get confused. You outline it, do a great detailed email. For something like FISP, like the facade safety program, you want to tell them exactly when their line is going to be done. You break it down by line so that they know they need to keep their blinds shut. Simple things like that, you communicate all of it, it really saves you down the line. Because otherwise you have frustrated people. I was changing and somebody was using an elevator outside and they looked in on me. You don't want that. You want to make sure everything in advance is set so people know. Then you send the reminders because the system we use, we can actually do it by line. So we don't have to bother everybody. The G line, today it's going to happen. We'll send an email. You populate it to send at 8 a.m. so people know. As the reminder, today the people are going to be using the lift starting at 9 a.m. Please close your blinds. Or the water is going to turn off at 9:30, only on this line. People get really confused. I'm in the A line. Why am I finding out that the G line is losing water? Like, I'm not losing water. Am I losing water? Like, you get a lot of questions like that. So I think to be as detailed as possible and to set reminders to send out to the community really, really goes a long way.
And also setting up ownership of tasks. I think that's very key and paramount. Sometimes we see it, or in previous, when we're taking over, where boards are doing certain tasks of almost managing the building, and then it's overstepping on several other factors of, who's responsible for this, because it's a lack of communication between everything. So when you have clear expectations of what is our role and what is the board's role and what is the super's role, and making sure that who's responsible for each task does really help clear a lot and streamline a lot of the issues.
I did not know that you can actually streamline communications in such a way to affect only designated, units. Every time I've gotten one of those emails, I've thought the same thing. Why is the A line losing water? Am I going to be losing water? Am I next? But that's an interesting way to look at it. So going back to operations, because I'm very intrigued, and I think our listeners are very intrigued in how property management is operated sufficiently. What operational failures would you say most become legal problems later? Like, what is it that you have seen in your day-to-day business that is the most common problem, and how can you address it? And how do you see it impacted legally?
A lot of things stem back to outdated documents, not keeping an eye on it. Also, not keeping best practices for a lot of things, and not having a process for, let's say, either a lease, an alteration, and letting things go through improper channels, and eventually you'll have somebody there who is not following guidelines and will open up a big legal liability.
I would say biggest also is on the financial end. There are so many things that could happen on the financial end. So we have like a 3-step approach that it needs to be obviously signed off by 3 different people before financials go out. For buildings that have retail space, you need to check rent escalations, tax escalations. That's super important. For just financials in general, there's assessments, there's increases. The memo needs to be there. Everything needs to be there. Everybody needs to check it, and that's super important because that could lead to massive legal issues.
And including checking all of the documents, from everything from minutes that the board's having, making sure that it's being updated and being taken. It's all really from important, or can open up to legal liabilities if you're not keeping track of it.
Can you give us an example, without naming a building and changing names to protect the innocent, of an example that you may have come across recently and how that played out, just by way of illustration?
Yeah, we have a building that we took over from another firm. I just think not just the sign-off process, but in general, double-checking things. We had a situation where a building was being charged, 10x for their insurance. And in reality, it turns out that when we looked at the policy, 2 of the 3 policies, not their flood policy, but the other 2 policies were for certain square footage, and the flood policy was for 10x that. So the building was paying 10x on that flood policy until we noticed it. We took over the building. We were like, why is that so out of whack? So it's just really important to make sure that, dot your I's, cross your T's.
Sounds like the building may have been almost underwater as a result of that flood.
May have.
Good thing you got them out. So gentlemen, in your now 1 year of PPM, what would you say the biggest or most common legal issue that you see facing landlords or condo or co-op boards that you represent?
So I personally oversee construction, and the biggest issue, and I've seen not just in 1 year, but over the course of many years, is access agreements, and it's gotten exponentially harder and more complicated, and the agreements have got to be more stipulated. Insurance requirements got much more stringent over the years. That's really something that can really push a project start date by many, many months if you don't get ahead of it ahead of time by starting making the right protection plans, knowing what your access will be to neighbors, getting your attorney involved, and starting up that negotiations is really paramount to any successful project, and how smooth the project will run.
It's funny you bring that up, because with the exception of a non-paying tenant or occupant, I would say that access issues are probably one of the most common litigations that we see here at the firm. So for those of you that don't know at home, whenever anyone wants to do work in New York City and involves a request for access for the neighbor, because if you're doing local law 11 work, which most buildings in New York City have to do for facade renovation every X number of years, they need to put up protections on the sidewalk, and if they have a building that's touching them that's close by, which is most of New York City, if you walk on the street ever, you need to put protections on the neighboring property as well. And it's amazing how many property owners, or specifically condo boards, don't know that much about this law, which is RPAPL 881, which is a statutory right for access. If you want to do work on your building and you need to put protections, you have the legal right to put protections on someone else's property. But you have to get permission for them to do so. If you don't get permission, you can then sue the neighbor for what's called 881 access to allow them to put protections up, to get a license for their property by court order. And there's a lot of things that go into it. You talked about insurance and how it could hold up a project, but the law provides that in certain situations, not all, but in certain or most situations, you're entitled to recoup most of your fees for architecture fees, legal fees, because the party next door is entitled to review the plans and make sure that it's reasonable, is the request reasonable, or figure out if the protection that's encumbering the property is the most reasonable protection to make sure that your property is safe. A lot of people in New York City just give access because they want to be a friendly neighbor, and that's great. You should always be a friendly neighbor and everything, but the biggest dispute actually I see with this is a condo board, and I just had this recently, a condo board gave permission to put up protections to do local law 11 work, and then the neighbor said, oh, I have to do work myself, so can we just do the same thing? And that board said, well, we want to be paid for you putting the protections on here. Depending on the scope of the protections, the board might be entitled to compensation in that avenue. A lot of times we see people get into fights over the fact, well, you know, because you did that to me, I'm now going to do that to you. I'm going to request a fee from you in the future. People need to understand how things can go both ways in requests for access, and that's always something that we like to explain to boards that may not be cognizant of in the future. We see a lot of disputes on that.
And sometimes it even gets worse. If one neighbor didn't charge the other neighbor a fee, the next time around they get more egregious in the amount that they're asking for to really get back on the last cycle. So it's really a fine line, and understanding who your neighbors are, and also trying to be proactive in the way that you deal with them, and know that you'll need access, they'll need access, and it's the way that New York works.
Yeah, I think it's great to get the reciprocal so that you don't have to keep dealing with it year after year after year, or time after time, I should say, because it's every 5 years. But didn't mean to cut you off.
Oh, that's quite okay. People do it all the time. But in any event, though, you both bring up really good points, but it's something that really varies on a case by case. A reciprocal may or may not make sense depending on that situation. It's just about making sure that everyone's informed, because sometimes there might be a legitimate reason to refuse access. It depends. Are the protections sufficient or not? I see a lot of people fight over the actual protections, saying we agree with you that you should do your work and everything, but we don't think that this is sufficient protection to protect us. It's really about making sure that clients are informed as much as possible from trusted construction experts, trusted property managers, and trusted attorneys to know what is the proper course of action, what makes sense for you in that individual scenario.
Yeah, and sometimes you could even have a roof warranty that's voided because your neighbor drilled into it. So it's a lot of moving parts, but it's good to have a team that's has really a way to review everything and present the best path forward.
Yeah, I mean, and sometimes boards do want to charge, licensing fees. I think there's things that people don't think of. Sometimes the protection needs to be on somebody's balcony, and they have no use of their balcony for 18 months. The board has to give them, depending on the bylaws or depending on, the lease, if it's a rental, sometimes there have to be concessions granted to the owner, the resident in the unit. So they have to take that into effect when they're asking for a licensing agreement.
It really depends on what the contract says at the end of the day. But also, especially with boards, since we're talking about that, it's always also interesting to see what comes up when they have board meetings and they announce that, okay, we're going to be giving protections for the neighbor that's doing this, or we're doing this in the building, or we're going to put up scaffolding. Seeing how all of the members of the community act and how to advise the board and how to handle the community and any questions they have.
And it's something you also have to explain in a way that they do have the right to do this by law. Usually the easiest way to do it is through an access agreement and seeing a cordial, because it is much cheaper than litigation. But if it does go to litigation and all of the protections are carried and they have everything in your best interest, they will get the access and you'll most likely not get anything out of it.
So we just finished talking about access. What would you say is the other most significant legal issue that you face on a day-to-day basis, if any?
So we as a firm are one of the most established, especially with our track record of opening up new condominiums, but also knowing what it entails for boards and helping them prepare for a board transition from sponsor to the actual residential board, and making sure that they are covered in their forensic engineering, they are covered in their attorney representation, and they're not letting off the sponsor without giving off any rights. I mean, you know, and you can, as a lawyer, know what those rights are. And those things can add up to a lot of money, especially in damages, if you don't have the right guidance and know what you're looking for.
We see that way too often. I always tell every sponsor or condominium developer, owner, that whether you're the best construction builder there is and you build the finest product, you will always hand off your product with something that's going to be raised as an issue. And oftentimes a lot of people will, they spend millions of dollars of their hard-earned money into these condominium units, and then there's something that they see that they may not like, or it just didn't come out the way that was advertised or was supposed to come out. There's always going to be a dispute. There's always going to be something where you have at least one, if not multiple unit owners, when you have a new board that sees something that isn't up to snuff in their opinion. And sometimes they're completely right, it wasn't, and other times it was, they may just have had buyer's remorse or something else. But it happens every single day. And it's one of the most important things, especially for new boards and for sponsors on both ends of the spectrum. Sponsors need to make sure that they did everything by the book, that they have a good property manager, making sure that the asset is maintained and that the community is maintained. So when they hand it over to the community, they make sure that they're handing the finest product over. And it's also very important to make sure that when you are a new board and that you just gain control from the sponsor, that the property management you have in place, whether it's the existing one or you bring in your own that's viable, fully informs you of what your rights are, what is practical, because a lot of things also just come up in new construction anyway that is routine and that will be fixed, but it's making sure that you're properly advised. And this way you can have the right discussion with your representatives and with the sponsor to have everything resolved as amicably as possible.
And also just as a property manager, some developers are no construction in and out and way better than us, but they miss sometimes a lot of things on the maintenance side, which will decrease life equipment and cause damages throughout. So we as a property manager specialize in operating a building and knowing what it takes to maintain it. So a lot of times we do see things that are not being done that will cause equipment damage over the years that will be significantly more than the maintenance of it. So it's also putting in place these best practices to avoid any damages, especially on such new equipment. And a lot of times it's very expensive equipment.
How do you handle that, Ernest, when you have a sponsor that may just like to do things that way, just do the bare minimum and go on their merry way? How do you make sure that you get them to do what you think is the best thing to do? How do you advise them?
So not just new developments, but like any other building we take over, we have a master checklist of preventative maintenance that should be done system by system, and then we filter out whichever one is not applicable. So when we're looking at HVAC, we're really thinking about it. What do we need to do for this? Water treatment. What do we need to do for this? These are just, samples of it, BMS and so forth. And when we do it, we're advising the sponsor, if you don't do this, this would be the potential damage you have in the future. If at the end of the day, the decision's not ours, but if we're giving the facts the right way, most people are reasonable and will proceed with the recommendations of doing the preventive maintenance.
Gentlemen, I got to say, we talked about a lot today, and I think this was very informative for a lot of our listeners. Before we go, is there anything that I didn't bring up that you want to discuss? Thoughts, complaints, criticisms, anything at all, gentlemen?
Call PPM.
How do we call PPM?
You can call Peninsula Property Management. My cell is 917-981-8250 for all the listeners out there. jdavis at ppmnyc.com. Please send us anything you need.
Giving the cell phone. I like it. That's accessibility. That's important. Ernest, how about yourself? How can people get a hold of you?
646-894-7065 and ERRIKA@ppmnyc.com.
And do you have a website?
ppmnyc.com.
I'm going to check it out. For those of you that have legal needs, I'm Alex Estis, member of the firm's litigation department. Call me at 212-551-1204. That number does go straight to my cell. And my email address is aestis@rosenbergestis.com. Take a look at the website. Take a look at the other podcasts we've done. Take a listen. Thank you for joining us today. Joel and Ernest, thank you for coming inside Rosenberg and Estis, located here inside Rosenberg and Estis. Thank you so much for joining us.
Thank you for having us, Alex. We really appreciate it.
Thank you, Alex, for having us.